Hi, everyone. Thank you for joining us. Although the defense is the last in the series, we believe we're the first in the series in many ways because there's a lot of opportunities to engage these evidence-based practices with our clients and with all the other stakeholders and use them in a way that's beneficial to, in particular, our clients, but to everyone in the system to make it more fair and more efficient. So I'd like to start, if possible, if the polling system is working, shall I do that right now and take a poll by asking you all which categories shown on the screen best describe your current professional roles? Is that possible to do? There we go. I think we've got about 60 people online. If you all would just select one, and if you're not there, we apologize. We probably should put other. But let's see if this will take. Okay, and while that's happening, I think what I will do is start by just setting the stage, if you don't mind. I want to make sure that everyone understands the purpose of this webinar, and that is basically we are looking at the evidence-based practices in today's criminal justice system through the defense eyes as well as other stakeholders. We are looking at federal, state, and local when we talk about evidence-based practices and where they would land. Let me just describe the poll results because it's exciting that the poll system worked. Defense Counsel, we have 20%, and community corrections, there are 38% of the participants from community corrections, which is also great. Local, state, federal, jail, or prison facilities, 7%. Thank you for joining us. The judiciary, 11%, judiciary and also legal counsel. And researchers, consultants, and there we do have others at 24%. So thank you very much for this nice array of participants. And now what we'd like to do is highlight what the goals are for this webinar. First is to emphasize how evidence-based practices are taking a more important role in recent system reform efforts across the country. Second, we'd like to discuss the role of defense counsel in using evidence-based practices, both the benefits and points of concern. And third, we want to determine how defenders can use evidence-based practices to provide better quality representation for each and every client. Before I get to the sea change, I just want to make sure everyone is also on board with the language that we use. I know that in each different community within which we work, there are sometimes terms that are thrown around or acronyms, and I'm hoping that during the Q&A you all ask us more questions about this. But when we say defense attorney, what we include are public defenders, assigned counsel, contract attorneys, and private criminal defense attorneys. And when we refer to the word client, we mean an accused person or offender, and many corrections agencies also refer to them as clients. When we also refer to these evidence-based practices, we're considering that these practices will apply to pre-arrest, bail, diversion, post-conviction, probation, and parole. And when we refer to the holistic model, we're addressing what drives a person to offend or engage in criminal behavior. Really what we're looking at are the underlying problems that led the person to go into the criminal justice system. And certain defender offices across the country have different ways of engaging in holistic representation. Sometimes it means working very closely with a social worker or a civil law attorney who will secure housing and benefits for a client to stabilize their life. And in other ways, a whole office is designed around holistic representation. So let's talk about briefly the sea change just to set the stage again. What we know, and I think it's just a given, is that our country has seen over the past 2 decades or more an incredible rise in the correctional population. And this includes pretrial and post-conviction. Incarceration is very expensive. We know that these are times of economic hardship, and legislators and communities are taking note. We are seeing that people are saying there's not much of a return on an investment if we're not careful and deliberate in the way that we are incarcerating individuals. They've observed recidivism in some jurisdictions where over half the prison admissions were for parole violations and revocation issues and nonviolent offenses. Others are saying this is too costly, therefore the policymakers and law enforcement and corrections and defense lawyers and judges are paying attention, saying let's look at this more carefully. Also, the corrections world is changing. The bar has been raised in that there are expectations to get people through the prison and get them into probation or parole and to reduce recidivism. We know that in some offices, the daily work is changing. We have corrections, probation, and parole professionals who are actually developing the skills to engage in cognitive behavioral techniques, looking at motivational interviewing, and in fact realigning the belief system or trying to realign the belief system of many of the offenders. So what we see in that sea change is an awakening in corrections and other stakeholders as to how to do this right, or at least more effectively. And defense lawyers have a very important role in this. We also know that evidence-based practices have to be carefully studied and monitored as they are used. Defense lawyers have been engaged in this work and trying to be problem solvers for their clients, those who are good defense lawyers and have the time to do it right, when we know that they're not always brought to the table. What we're hoping that this will do, this webinar, is to increase the understanding among defense lawyers about evidence-based practices and understand their value in the advocacy process. We also hope that defenders will understand the tools that they sometimes cannot be used for clients, or if they're used, they must be used properly, that they do have limits. And we also understand that evidence-based practices can be a negotiation tool with prosecutors and others, and when they're not used properly, their job, their ethical obligation on behalf of their client is to raise that red flag. So we'd like to see a focus on reducing recidivism, but not at the expense of constitutional and other protections that clients have when they enter the criminal justice system. We also would like to see a refinement of sentencing and correctional policies and practices. We know that there are practices that work and some that just don't work. We believe that defense lawyers have a role in being advocates both in the courtroom, pre-trial, post-trial, but also in the policy-making circles. Defense leadership is not always clear in some states, but what we have seen is that many states are looking to play a more active role at the policy-making table. And some have even worked with lobbyists in order to ensure that there is a balanced voice at the policy-making table. So let me highlight one other piece, and that is the dangers of perhaps or red flags for evidence-based practices in the daily work of a defense lawyer. Defense lawyers and defense teams must ensure that evidence-based practices are accurate and that the program doesn't make someone worse off, meaning we want to do this with fidelity and with fairness. If you don't do it well, we can place the wrong people in the wrong programs. And it's just like when you have a great new program. Sometimes it has the sparkle and everybody wants to send people to that great new program. It's not always the best result. It can backfire. For example, if you have a low-risk person and you may actually increase the risk of recidivism if perhaps you put them in a boot camp, but then pull them away from what makes them low risk, for example, their family support and a job, then you may actually increase the risk that they are exposed to, and they can assimilate back into their community, family, or job as well. So representation is critical. We need to know what's going on with our clients and how they are exposed to these tools and how they can be used effectively. So I want to just highlight the evidence-based practice principles that were in the paper, the box set, and make sure that everyone is on cue with what we mean. There is extensive research on defendant behavior and correctional and criminal justice practices from which we can distill several core elements on what works in reducing recidivism. As you see in front of you, these are the 8 guiding principles. These are based on objective, information-driven methods of assessing the needs of defendants and responding to those needs in proportional ways and effective ways throughout the criminal justice system. If you look at the bottom, and I'm going to fly because we want to make sure we get to our presentation and the questions, but at the very bottom of this ribbon, which I really like because it's a continuum, the risk and needs assessment. So that's an actuarial risk, and the defense lawyers have a role to play in making sure that it's accurate. And the next is that they move into the looking at the enhanced and intrinsic motivation of what's going on. Whoops, oh, there we are, sorry. Identifying the risks to reoffend that drive criminal behavior. What we're trying to do is target resources to reduce the likelihood of reoffending. And identifying those resources, not all jurisdictions have those resources. We understand these are times of limited resources and in many cases in defender offices cutbacks that are quite serious. But that doesn't mean we don't look to the evidence-based practices when they're available and see what can actually reduce recidivism and improve public safety and avoid squandering resources on what does not work and what may actually harm a client. Next. So when I talked about those principles, the ribbon, I'm not going to read to you. That's nothing more worse than a PowerPoint when somebody reads to you. But I want to just highlight here the 3 circles. And what's really great about this is that it shows that you can't just take a tool and throw it into a system and say, let's see if it works. There's really a thoughtful method of putting this together in an integrated model. The evidence-based principles underlie this whole practice, these policies and practices. But it requires collaboration with all the stakeholders. And why we as defense lawyers need to be at the table is to ensure that there's a balanced voice. And we'll talk about that with some of the practitioners who are on this call. And then a critical element to that is the organizational development field. We know that that field has also had quite a sea change or a growth. And it's important to know that organizational development tools within not only offices like corrections, prosecutors, and defense lawyers' offices, it's important within the whole system. And we must align those developments of the office with the principles and values of evidence-based principles. So these overlap, and if we have policies that are collaborative, that we are interdependent, we're sharing information, we're saying what works and is not working, we're tagging those that are red flags that need to be adjusted or cut out of the system as a whole and redone, then we know that evidence-based principles will be accurate and fair. And that, we believe, with a targeted practice, will reduce recidivism. Next. So the holistic approach fits nicely with this because we, as holistic defense lawyers, try to say, this person is a whole individual. There are reasons why this person ended up in the criminal justice system. It didn't just happen in one bad decision. So we look to the underlying problems, and we try to understand what's going on. What we do is look to assessment tools. Now, the targeted interventions vary from place to place, but we know that with targeted interventions, we can reduce recidivism, and we'd like to hear from those of you who are on this call more about how targeted interventions can work and where those areas of challenges still remain. And we are looking for behavior change. Now, that is over a long term. We all know it's very difficult to change behaviors, but it is possible, and that we need to be vigilant in ensuring that those tools are accurate and used in a very fair and faithful way to the system, so that it's all a piece. The tension between policy and client advocacy is really the nutshell here. One of the problems is that sometimes it's not appropriate for a defense lawyer to engage or to push their client or to allow the assessment tool to be used. We'd like to talk about that. I'm sure that's a hot point for some people, but also we want to make sure the policies have the defense lawyers at the table and that they're at the table with an authentic voice. They're not just rubber stamping. Next. So the potential pitfalls we've raised a little bit, and that is fidelity to the entire system. Those bands that I discussed, the ribbon, the principles, as well as those 3 circles, that if we don't have organizational development, we don't provide fair resources to both the prosecution and defense and to the correctional officers and others, then it's not going to be faithful to this system of evidence-based practices and it won't work. We're also concerned about net widening. Taking that person that I use as an example where it might be a low-level offender, a kid who's joyriding and gets thrown into a boot camp and pulled out of the support networks that might help reduce recidivism, it may actually widen the net into low-level offenders or others, and it may backfire. Organizational development, defense leadership is critical. really critical in the organizational development. What we know is that in many states, defense lawyers haven't had a leadership role. That's one of the reasons many of those on the call today were involved, or continue to be involved in the leadership training of defense lawyers, because we are part of the system. We're not just individual counsels operating separately. We have a role at the state, local, and federal leadership level when setting policies, and leadership is critical in having a voice, but also understanding how to listen. Next.